Wonderful. Yes, good evening, and thank you so much for joining. I really appreciate it. My name is Lisa Mathews. If you don't know me, I'm an estate planning attorney in Virginia, and today we're going to talk about estate planning for parents. I'm going to focus on really any parents, but specifically I'm going to talk a lot about parents of minor children. We have quite a bit to cover this evening, and I'm very excited to go through it. I don't want to keep you here all night long, so I've been very careful to try to choose content that I think is the most important content for you. It's certainly not comprehensive in terms of what you would need to know for an estate plan. However, I will absolutely give you some instructions on how to reach out to me at the end. I also have some gifts at the end, so please hang on. But what I'm going to do now is just share my screen and get going. So let me do that. All right, so what I've got going here is a PowerPoint presentation, and I really hope that the slides make it clear. And again, please know that we're here to answer questions afterwards. I'm not going to really be answering questions as a part of this webinar, because instead it's going to be, I'm kind of just trying to get through information. So there's really not time, unless I had you here, like I said, for a long time to go through specifics. So I'm going to just kind of go through everything, and then I will absolutely give you a way to reach out to me. Okay, so let's dig right in. So as I said, my name is Lisa Mathews, and I am an attorney. This is my 5th year since I founded my own law practice called Mathews Law. I practice estate planning, and I have in the past practiced quite a bit of family law as well, although I don't do that as much anymore. I'm an adjunct professor at George Mason University Law School, and I absolutely love serving Virginians. And I should just point out at the beginning, nothing I'm going to say right now is legal advice. We lawyers like to remind people of that just in case. But also, I am licensed in the state of Virginia. I'm not licensed in any other state. So this is Virginia-specific information. It may be fairly broadly applicable to other states, but if you happen to have joined from another state, I really don't know the law in your specific state, and so you'd want to talk to an attorney in your state if you have any questions. Okay, so what we're going to do this evening is we're going to focus on some introductory principles and some basic topics, and then we're going to jump right into assets. How do assets get passed from you to the next generation? We're going to talk about generally how assets are passed, and then we're going to talk very specifically about how assets pass to minors. Very important. We're then going to talk about how to name guardians and the types of guardians that are named on your estate and for your children. And then we're going to talk about, as I said, some gifts that we have for you and how to chat with me if you have any further questions. All right, so let's start off just talking about estate planning generally. And conceptually, just really important to know is sort of what do we mean by estate planning? First of all, an estate is really just everything that you own. So sometimes, you know, we don't walk around, I think, using the word estate when we think of our belongings. And yet an estate actually is just, it's just everything that we've got. So that's really what the definition of the term is. Estate planning is really, it's creating a strategy that documents your wishes for your estate in the event of your death or disability. So sometimes people don't think about disability, but disability absolutely is part of estate planning. And it's also planning for your children's well-being after your death. And that's obviously an incredibly important part of it. As we get started with estate planning, I always want clients to start by telling me what their goals are. So when you're thinking about what we're trying to do right now with estate planning, you think, well, a lot of times people think of it as, well, I've got to get documents in place. And it's very true, you've got to get documents in place, but the documents are really for a purpose to establish what your strategy is for your family, for your loved ones. And so it's a good idea to start off before you start thinking about documents to consider what is it that you want to accomplish. And since we're here talking to parents more specifically, parents, What are your primary concerns if something were to happen to you? One thing that is, it's an unfortunate reality, but in thinking about this, and this obviously makes you such wonderful parents that you are thinking about this, but as we consider what would happen to your children if you died, consider that that would change the course of your children's lives forever. And so thinking about, it's not just, how do I get my assets to my child and who's the guardian? It's how do I set my child up for the best possible life if something were to happen to me as the parent. Other goals that you may have, as I've sort of got listed on the left here, you may have a child that you think may be a special needs child eventually, or is a special needs child now, or may have special needs later that need to be funded. You may be worried about disputes that you want to avoid. You may be thinking about the tax implications. You may be thinking about, how do I make sure not just that assets get to my child, but I want them to go to the next generation as well. And I'm not sure that my child's actually going to save any money for the grandkids. And so how can we do that? So considering sort of all of those things is really good before we start actually getting into documents. One thing to note as we work through some different solutions is I'm actually going to identify multiple ways that assets are passed to children, and you're going to see that there are different options. However, the options really fall on a spectrum, and so I tried to sort of articulate it here with this slide. But if you have, there are options that are less expensive now for sure. I call them minimal solutions, but they're more simple. And I completely understand the need to say we've got to put an economical plan in place because we just don't want to spend a lot of money on estate planning. And I completely understand that. But what you should know is those economical options tend to cause more issues later or more cost later that eventually does come out of your estate. So it's sort of paying for it now or paying for it later. That's one thing to keep in mind, is that the most economical solution right now may not be the right option in the long run. And we will talk about those in just a minute. There are more robust solutions that provide, greater asset protection, greater protection against other concerns that you may have, but they tend to cost more now. Now, it is possible to have an estate plan that is too complex. And so I don't want people to go out and think I've got to go spend all the money on everything. And I've got to have this crazy, robust estate plan that's just so complicated and expensive because I want to prepare for any potential eventuality. It is possible to sort of overdo it with estate planning, but I think that what tends to happen instead is people kind of tend to go on the more economical side of it. And then what happens is there are unintended consequences that happen later. So I will point these out as we go throughout, but I just want to point out that it's up to you. You're the decision maker here. So what is the right amount of risk? What is the right amount of planning now that you want to do? Are there more things that could happen later that you want to make sure that you've thought about? So that's just, this is just sort of something to really think about as we kind of move through these various options. Okay, so some basic estate planning topics. So first of all, I should mention, I'm about to get into some really basic stuff. I have completely left out some really important concepts. And the only reason I've done that is because we're really here to focus on taking care of children. And so I really wanted this webinar to be about that. So I've really left out some things, and I said that a minute ago, but I just want to be clear that there's quite a bit more to estate planning than what I'm going to point out. But we're going to jump right in. I want to kind of start off with the financial stuff. And so I want to jump into some of the basic concepts as we get into that. Okay. So first of all, people are familiar with a will, but just to be clear, what a will is, a last will and testament, it is sometimes called. A will it has multiple functions. And one of the things that it does is it allows you to name a personal representative who is responsible to settle your estate. So that's somebody that you name. That term personal representative is sort of what we call it in Virginia. It's throughout the code in Virginia. You can also just say executor. Executor is, I think, the more common term for this, but personal representative is typically what we use in Virginia, and it's what you're going to hear me say today. Your will also lists beneficiaries. You can put beneficiaries in your will. Now, we'll talk in a minute about other ways to pass assets, but that's for sure a way to pass assets. It also allows you to name guardians for your children. both physical guardians and financial guardians, if you wish for those to be separate, or you can name those guardians for all of your all of those as one person if you want. So we'll talk about that in just a minute as well. It also deals only with assets that do not pass directly to the beneficiary. So it's a misconception that the will handles every asset. It doesn't. It only handles some assets. We'll get to that in a second. And then you should know also that if no will is in place, there are default rules in Virginia. They're called laws of intestacy, which define how your assets pass. And so that's because obviously, as you can imagine, there are a large number of people who don't create a will, but their assets have to go somewhere. And so Virginia has default rules in place, which are, I think, what you would sort of expect. It's generally speaking, assets go to the spouse if there's a spouse, otherwise to children. If there's no children, parents. If there's no parents, then it goes out to siblings and then their children. So it's sort of, you know, if you look at a family tree, it kind of goes around the family tree until it finds somebody who can take the assets. But we don't need to worry about that because everyone here is going to have a will. Another topic that is going to come up today that I'll mention multiple times is this concept of probate. And this is really, really important to understand. Probate is a process where the court provides oversight to the distribution and settling of accounts of estates. And so what happens is after someone dies, that personal representative, someone has to go to the court, they have to get qualified as a personal representative. And then any assets that have passed through the will, and I say that there are exceptions, but for the most part, assets that pass through the will are probated. And that means that they have to be inventoried, they have to be accounted for to somebody who is assigned to do that in every jurisdiction. And that person is called the Commissioner of Accounts. And every jurisdiction in Virginia has a Commissioner of Accounts. And that person receives these filings and reviews everything. And really, the Commissioner of Accounts is making sure that estates are settled and that beneficiaries are given what they're supposed to have. And so the Commissioner of Accounts really looks for, are things being abused in the estate settlement process? And they also look to make sure that, you know, taxes are paid and things like that. This process requires a fee, and it's dependent on the size of the probated estate, but there's a fee for the personal representative to qualify in that role. There's a fee every time documents are reviewed by the Commissioner of Accounts. And it might require, there's a way for this to be waived, but it might require a bond to be posted for the personal representative. This process for some personal representatives can be very difficult because that accounting requires every single penny of every single account be accounted for to that Commissioner of Accounts. And so people that are familiar with this might be able to tell you about how frustrating it can sometimes be. The other thing that people sometimes are concerned about with probate is that it requires that the will be made public. So the will becomes a public document, and any instructions that are in the will around particular beneficiaries, for instance, that becomes a public document. And so if you're concerned about that, that is one of the functions of probate. Okay, another big concept we're going to go into actually a lot in a few minutes is the concept of a trust. And some people are familiar with trust and some people aren't. So just to kind of provide everyone a baseline understanding, a trust is an instrument, you might say an entity, that holds assets that are transferred into the name of the trust, and they're managed by a trustee. That trustee has to distribute the assets according to the rules of the trust, okay? We will go into trust in a minute, so if this is a new concept for you, that's just fine. We'll go into that in detail in just a minute. Trusts are very, very flexible, and they allow you to really dictate how your assets are used with more flexibility than a will. And again, I'll talk about this in a minute. Assets that pass through a trust that are created if the trust is created in your lifetime, then that probate process that I just discussed is avoided. If the trust is created as a part of your will, then the probate process is not avoided. And again, we'll talk about that in just a second. Okay, so that's kind of the preliminary stuff. What I want to do now is really get right into how assets pass at your death, okay? I'm going to focus primarily on the assets that most people have. So I'm going to focus on these 5 assets: your home, retirement accounts, checking and savings accounts, investment accounts, and life insurance. payouts. Just about everybody has at least one of these, if not more. Now, there of course are other kinds of assets that you could have, and all of these assets have, you know, some specific peculiarities around getting them passed over to the next generation. But I'm really not going to focus on those things. So these are the 5 things that I'm going to focus on. Okay, so after you die, there are 4 ways that that assets can pass to the next generation. One of the ways is joint, and let me clarify that assets can pass to another person. It doesn't have to be the next generation, but assets that are in these scenarios go to whoever we'll talk about. It's not necessarily the next generation. And in fact, I'll say as I get started into this slide, minors cannot receive assets directly. So that's something to keep in mind. When I'm talking about these 4 things, this is really to an adult. We'll get into minors in the next slide, but just to be clear, you would never name a minor for any of these assets directly. They cannot receive these assets. Okay, so one of the ways that assets pass is through joint ownership with rights of survivorship. So you may have heard of this. This is most typical with your home. If you are married and there are 2 parents and you've both got a home, it is very likely, if you look at your deed, that the deed specifically states that you both own the home with rights of survivorship. And that means as soon as one of you dies, the home automatically belongs to the other person. That is a great thing in Virginia, because in Virginia, if that's the case, then that surviving spouse doesn't have to do anything, file a new deed, and it doesn't have to notify. That deed already says that as soon as the first individual dies, that the second person still owns the home. And so it's yours, it's done, it's yours. Other types of accounts that this can happen with are, bank accounts. If you have more than one person on a joint bank account, then it's the bank account belongs to both. And that second person now owns the assets in the bank account. And then it can also apply to investment accounts where you have multiple people that are named on an account. Now, one of the questions that came in prior to this webinar tonight was, well, can I not just add my adult child to my home and then let's just pass the property that way? And that's just so easy because then it's already my child's. I'm going to go in a minute about other ways to do it that are better, but this is actually not advised to do. And briefly, the reason it's not advised to do, one, is when you do that, you're giving your child a gift in this lifetime. And that asset now is owned by both of you. It's owned by your daughter. If it's your daughter, it's owned by you. If it's you, you and your daughter or whomever own the home. And then that's now an asset that could impact, could be sought after by creditors. It could impact the ability to apply for bankruptcy. There are a number of things that could get in the way. If your child is on that deed, then your child actually owns the home with you. Another reason to do it is it could impact taxes if your child later wants to sell the home. There's a rule that whenever a property is sold, first of all, just generally, when you buy property and it costs, say, $500,000, then you sell the property at, say, $900,000, there's that capital gain that has to be taxed at the sale. When somebody dies, there is something called a stepped up basis, where the beneficiary who seeks to sell the property only has to pay capital gains from the value of that property from the time of death of the person who owned the home. So if you gift that property to a beneficiary prior to your time of death, you're removing some of that benefit of the capital gains, and it gets calculated based on the date of gift instead of on the date of death. So you could be increasing taxes for your child if you want to do it, if you do this by adding them to the deed. So it's really not recommended. There's other reasons as well, but those are sort of the main ones. Okay, another way that assets are passed after death is through accounts where the account is set up such that the assets go directly to the beneficiary. So the will doesn't have to be consulted at all. These accounts are accounts where there's a beneficiary designation, such as retirement accounts, right? You have a 401k, you name a beneficiary, the financial institution can provide the money directly to the beneficiary after you die. Nobody needs to look at the will for that. The other kind of account that this applies to is transfer on death or payable on death. So you'll hear those called TOD or POD, designated accounts. So that is where you have, many banks have this. You can even have a checking account and a savings account that is a payable on death account. And then that account as soon as it's got that beneficiary on it, it transfers directly to the beneficiary, and it doesn't have to go through the probate process. It doesn't have to go through the will. So that's the second category. The third category is the will. So if something goes through the will, then what that means is that the personal representative, as the person responsible for your estate, receives assets as once they've qualified to be the personal representative, they receive assets for the estate. It has to sort of all go into an account that has the name of the estate on it. And then that personal representative pays off all of your bills and your debts. And then that personal representative looks at the will and everything gets passed out to beneficiaries based on the will. And again, yes, the probate process is required. You'll note that I listed all of the different kinds of accounts as accounts that could be subject to this. Homes are very commonly, they very often go through the will, bank accounts, investment accounts. Insurance payouts and retirement accounts do not typically go through will. That's actually quite rare because, first of all, if you have an insurance policy, the whole purpose of that was to bless the lives of your beneficiaries. And so you likely remembered to place a beneficiary on that account. And the same with a retirement account. Retirement accounts, you've likely named a beneficiary. And if you haven't, a lot of times retirement accounts will have default rules in place that say, well, if no beneficiary is named, we're going to give it to the spouse or to the children. So those are actually quite rare to go through the will, but they can. If there's nowhere for those accounts to go, or if there are not default rules in place already with those institutions, then it has to go to the estate. And what'll happen is they will literally, they'll write a check to the estate, and then it goes through the same process as any other asset. Okay, and then the last thing that we're actually going to get into some more detail about is you can also pass assets through a trust. So if you create a trust during your life, or you can have a trust that is created with your will and created at the time of your death, and then assets can go through a trust. I will mention that if you create a trust in your will, it's really the third thing here because the probate process is still required. And we'll talk more about trust in just a second. Okay, so this is like a primer, a high-level overview of basically how all the assets that we talked about, the 5 that we're focusing on, how these pass to other people. Let's get into some more specifics about minors. All right, now, so if you have an adult, let me just go back. If you're not passing to minors and you have an adult that you're passing, all of your assets are going to adults, you've got adult children, then any of these, you're the one that can decide, but many of these options are great ideas, and depending on your needs, you can kind of pick and choose based on the asset. I do want to point out, I was going to mention this and I forgot that I mentioned on the second category that I put home as something that can go directly. Well, Virginia has a really cool law that you can actually file something called a TOD, transfer on death deed. You create this deed, it sits on the record of the court, the land records, the area of the court, and it just sits there, and it's where you say, when I die, my property goes to this person. So to the person who is thinking of adding their child to their deed, you don't need to do that. You can actually just file this TOD deed, and then the home is yours, and then when you die, the home automatically goes to your child. No further deed is necessary. It's a very easy process. Okay, now let's talk about minors. Okay, so as we think about the world of children who are under the age of 18, they need to receive assets, but assets cannot go, as I said a minute ago, they cannot go directly to minor children. So we have to come up with other ways to do it. And there are 3 ways that assets can be left to children. And I want to mention, I've got this in the upper right-hand side, but I'm specifically not talking about business interest. I'm not talking about 529 accounts. So there are other sort of more rare things that can happen that, for sure are a way to pass assets to minors. But these are the primary 3 ways for the assets that we're talking about. The first one is that you can leave the funds, you can leave the assets to the minor to be managed by the guardian of the estate. What is the guardian of the estate? We will get into guardians at the end of this presentation, but a guardian of an estate is somebody that can either be named by you in the will, or can be or is named by the court. So it has to be named by somebody. But this person is appointed to manage the assets for the child until the child becomes 18 years old. This is, I put not recommended on this one. It's not recommended. Here's why. This process requires this guardian of the estate to provide not just the initial, you don't just initially have that probate process when you die. This guardian of the estate has to report back to the court, to the commissioner of accounts every single year until the child turns 18. And there's a fee involved, and there's often a bond involved. So that money gets whittled down every single year. And then when the child turns 18, the assets have to go to the child. I had a client who, this scenario is what happened. A father had named his son, 2 years old, as beneficiary to his retirement account. Very loving thing to do. He didn't think anything of it, but he named his son. Well, father dies, child is 2, mother, now, mother has obviously is the guardian of the child. Even though she's the mother of the child, she had to go to court and get appointed to be the guardian of the estate just to get the money, get access to that 401k money. And then, like I said, she has to go every single year to the commissioner of accounts and file an accounting. Now, I think this was maybe $20,000. It wasn't a lot of money. And every single year she's having to pay fees and, file this accounting, maybe hire a lawyer to help her. So not a good thing. All because very simple thing is the father just left it, left the asset to his child who was under 18. So this is not recommended, but by default, this does end up happening because so many people don't realize this is what happens if you leave assets to minors. Okay, so that's the first one, but we don't need to revisit this one because it's not a great choice. The second one is that you can leave money to the person that you think is going to be the guardian, that you've named as guardian for your child. And this is, this is definitely something that I've seen. If you know that your sister or your brother or something is going to be the one who takes care of your child, you could say, well, I just want my money to go to that person, to my sister, and then my sister will take care of my kids. So, and I think, I think there are scenarios where that might be an okay idea. There are definitely things to think about with this. That is, first of all, what if the person ends up not qualifying as guardian, right? You've now left this person cash, but they don't have custody of the child. Second, how do you know how the money is going to be spent? Once you give the money to the guardian, then the money is technically owned by the guardian. So how is it going to be spent? You really sort of lose the right to dictate that. That's sort of okay if you really trust the person and I don't know, it's possibly okay depending on the dollar amount, but honestly, it's not the best idea. And we'll get into a better idea in a minute. The other thing to point out is the reason I have it on the right, it's okay for smaller amounts, is because if it's a small amount, I can sort of see doing this. But remember, if it's a large amount of money and they invest it and they start getting gains from the investment, that's actually taxed to this guardian. So you've added to their taxable income. Or if you have, pre-tax money, say from a retirement account, that's actually taxed to the guardian because they're the ones receiving it. So there are some issues with that, right? Do you want the taxes to be eaten away based on their tax bracket? Do you want, that's also sort of not fair to them, right? So again, I think if it's a smaller amount and you just want to give it to the guardian, I think that's fine. But if it's a life insurance payment, should that go to the guardian? Possibly not the best idea. Okay, and then the last way is through a trust, and like I said, we're gonna get into trust pretty detailed, but trust can be really great ways to deal with some of these things. So as a reminder, trusts are instruments that hold assets that are transferred into these trusts. There's a trustee who is responsible to execute the rules of the trust and distribute assets. And one thing to keep in mind as we work through this is that a minor's trust does not have to be managed by the same person as the guardian. So you may have really good reasons as you kind of consider, if something happened to me, who's going to get guardianship, who's going to manage assets. You can absolutely name a different person for that if you would like. We're going to focus on the 4 categories of trusts on the right here. So the Uniform Transfers to Minor Act trusts, revocable living trust, testamentary trust, and irrevocable trust. You might have heard of the UTMA. This is sort of a popular type of trust for, especially for certain scenarios. But what this is a law. It's actually been accepted by almost every state. It allows you to leave money to a child in a trust. Pretty simple to set up, but there are some rules. First of all, it is managed just like other trusts. It's managed by a trustee. In this case, it's called a custodian, until the child is 18 or at the most 21. So it's 18 in Virginia unless you specifically designate when you create it that it's the child can get the money at 21. You cannot do anything to expand that. So if the child starts to be 14, 15, 16, and you start to say, uh-oh, there's a lot of money waiting for this person, and I'm not sure that he or she is really going to be mature enough to receive this money at that age, you can't do anything about that because that's when they get access to the money. You can create a UTMA account when you're alive. You can also have it created as a part of your will. If you create a UTMA account while you're alive, transfers into that account are irrevocable. So you cannot change your mind. Once you transfer the money in, it's a gift from you to your child into that trust. You can't change your mind. If you leave assets in your will to a UTMA account, whether it's an existing one or one that is created as a part of the will, then you have not avoided probate. The probate process is still required. And then I already mentioned you can't really change your mind if the child gets older and you're fearing that they're not going to be responsible to manage funds. And I actually had clients in this situation before where they had placed a sizable amount of money into UTMA accounts for their children. And one of the children was looking to be less than responsible as he was getting older. And they were worried, I think all our money is going to go towards a really expensive sports car. And that's not what we wanted it spent on. We wanted it spent on, education and first home and all of those things. So there are definitely drawbacks to using UTMA accounts. So I put here again that for smaller amounts, if you're in a situation where you already sort of know your child is going to be mature enough, maybe it's not a ton of money, you're comfortable with them pulling it out at the age of 18 or 21, fine. UTMA account can be good for that. It also, unfortunately, if it's gifted in the will, it doesn't necessarily avoid probate or that ongoing accounting unless that is specifically waived. So that's something to point out. If it's gifted in the will, it absolutely has to go through probate, but that ongoing probate, that ongoing accounting every single year until the child is 18, that actually is required unless it's waived in the will specifically. So people that forget to do that don't know that they're actually creating this responsibility for the custodian of the money. So those are UTMA accounts. Okay, the next kind of option for trust, and this is one I'll just give you the spoiler alert now. If you have minor children, this is absolutely going to be the recommended type of trust for most people. But it is a revocable living trust. A revocable living trust is one that is created during your lifetime. And the way that it works is you have the entity created, you are the trustee while you're alive. And so while you're alive, you have full control and authority over the trust. You can put money into the trust, take it out, you can spend the money however you want, you can amend the trust, and it's revocable, which means you can actually end the trust and change your mind. So it's completely your money. You can also name a backup trustee. So if you are getting into a position where you're thinking, you know what, I may not be able to manage my affairs as I get older, you have a trustee already named in your trust, and then that person has authority to come in and manage assets for you based on the rules that you've put in your trust on your behalf while you're experiencing whatever difficulty you're anticipating. These are, like I said, they're fully revocable and amendable while you're alive. And I mentioned the retitling. So the way that assets get put in the trust is you retitle the asset. For instance, if you have real estate, it's very easy to do. We just file a deed that retitles it from you, and then it gets retitled to being owned by you, except you are now the trustee of the trust. So it's sort of just a formality, but that's how it gets transferred. You can also name a retirement account or a TOD, POD account or life insurance policy to feed to the trust after you die. And there's no probate for that because the assets go directly to the trust. As I talked about earlier, it's directly transferred from the institution. Any assets that are already in the trust or that are where the trust is the named beneficiary for those assets, completely avoid the probate process. I already mentioned disability planning. And one of the main benefits of these kinds of things is that it allows you to have control of how the funds are spent after you die. We're going to go into some detail about this and different scenarios. But after you die, you might want to really dictate, I need money spent a certain way when my child is a minor. And then I want it spent this way. And then I want it paid out over time, right? We'll talk about this in just a minute. These types of trusts they're revocable during your lifetime. They become irrevocable after you die. And that's great. That's what you want, because after you die, your trustee now has to follow the instructions of the trust. The trustee cannot come back and say, well, I didn't like that my dad said that this is what the money can be spent on. I want to spend it this way. Actually, the trustee doesn't have that authority, and that trustee has to execute based on the trust. And then I mentioned, you know, I think it's highly recommended. It's for, especially if you have minor children. And it is a very common kind of trust. It's the most common thing that I have families coming into my practice for. Okay. You can have a trust created as a part of the will. These are called testamentary trusts. And I know, you know, some families choose to do this. And you do get some of the benefits of the revocable living trust in a testamentary trust, because in the will, you can say, create a trust that has these rules that are where the funds are paid out over time, over the years for my child. So you certainly can do that. And it doesn't benefit you while you're alive. You don't have anyone, you know, there's no trust that exists while you're alive, but after you die, you can have some instructions that a trust gets created, and then things are paid out over time and based on your wishes. However, this is really, in my opinion, not a great idea at all. And here's why, okay? First of all, if you do this, you have not avoided the probate process. So remember, with the revocable living trust, you completely avoided, for those assets, you've avoided that probate process. Here, because everything's going through the will still, probate still has to occur. The other thing is that now, remember, the will, when it goes through probate, is public. So now you've got very detailed instructions of how your assets are going to be paid out over the next however many years that are now public, because they've had to be filed with the court. So those are two, in my opinion, really big reasons why this is not the best option. However, this is certainly better than not having anything. So if someone decides to do this, I can understand it. If you don't want to do a revocable living trust, this is another choice, but I think that it's a better option to do the revocable living trust. All right, and then finally, the irrevocable trust, I'm really not going to go into these because these are very special trusts that are for a certain reason. They're really not recommended for most families, but I mention them because you may have heard of them if you've been looking into trusts. These are trusts that are irrevocable at the time of creation. So remember, a revocable living trust becomes irrevocable at your death, but during your lifetime, it's still revocable and amendable by you. An irrevocable trust does not have that kind of flexibility. It's usually used to reduce the taxable estate. So if you have an estate worth more than $12.92 million, congratulations. You probably should look into a irrevocable trust. It can also be used for Medicaid planning to reduce the size of the estate so that the government doesn't look at certain assets when when qualifying you for Medicaid. And then also for people that are really concerned about litigation, if they have really high risk jobs and they're commonly being sued, an irrevocable trust can be a way to move money away from their estate so that it's not subject to that litigation. That does not apply to a revocable living trust. That is still just as available for litigants as your own money, because it is your own money, but an irrevocable trust can provide that protection. So we're not really going to talk about irrevocable trusts other than for me to just point out that they exist, and here's typically why they get created. Okay. So there's a lot going on this slide, but I want to walk you through some of the choices, the way that a revocable living trust can play out, because this is really where the magic comes from for these kinds of trusts. So first of all, as I mentioned on the left side, while you are alive, the funds are used by you or they're used for you for your benefit. So I've already talked about that a little bit. Then at your death, they are no longer revocable. They are now irrevocable, and they're to be managed by the trustee that you've named in the trust. And as I mentioned, the bottom red box, the trust is made up of whatever is left over from those assets that were not spent for you or by you during your life. And then if you have life insurance fed into the trust or other assets that feed into the trust, now that trust is made up of all of that money. Probate has been avoided. Okay, so now let's get to how it can be really helpful. The very next thing that happens after you die, and let me just mention really quickly, if you're married and you have one revocable living trust between, you can have a joint trust that both parents are on, and then after the first parent dies, the second parent still has the authority to manage the trust as they wish and receive assets, use assets as they wish. And so then what we're talking about now would be after that second parent dies. Okay, so it doesn't matter if you have the trust is created by one person or if it's created by two parents. It can be one trust that has both parents' names. So while the children are minors, so say second parent dies or parent dies and you've got minor children, the options are that the trust, let's say that you've got children you've got multiple minor children, okay? The trust can be kept together in one trust, and that is often called a pot trust, not to be confused with marijuana, a pot trust or minors trust. And the way that it gets used is it's used based on the rules that are in the trust while the children are minors, okay? And that is a helpful way to do it versus this other way I've listed here, which you could also take that trust money and divide it into a separate trust for each of your children. The reason that I've actually bolded the first one because I think it's a better choice. And the reason for that is because your minor children, when they're children, you don't really know yet what sort of needs they're going to have. Just like in real life, different children have different needs and it costs different amounts, and you can't anticipate that right now. So having everything kind of remain in a pot trust, and then when they get older, you can have it pay out specifically to each individual child. But that's generally the most preferred way, and I actually see parents do that the most. What I have listed beneath that in that second column is things that you can provide instruction about how the money is used. This is one of the wonderful, very flexible things about these trusts. I have health, welfare, maintenance, and support in quotes because that is the common default language. So if people don't know exactly what they want to do, how they want to describe how money should be spent, that's a very common, it's for the welfare of my children, and it's up to the trustee to decide what that means. Now, you can also provide more specific things, and I've listed a few of them. So remember, we talked about that if your children die when they're minors, that changes their lives forever. And so being specific about thinking about their needs that they may have, you can say, I want this money to be spent on any therapy that my child might need. I want to make sure that their travel is paid for to visit relatives because they're going to need to have that connection with those relatives because we're not around anymore, right? I want to make sure that they're active in extracurricular activities. I don't want there to be any concerns about oh, this is too expensive. I want that to come out. You can even say that if the guardian, you've just given, your children now are going to be with a new guardian who might need to upgrade their home or purchase some items, and you want to make sure that those things are included in what is considered for the care of the child. So there's lots of other things, but this just gives you an idea of some of the wonderful things that can be done with a trust that follows, it's spelled out in the trust document, and the instruction is followed by the trustee. As the children get older, then the question is, well, okay, when do we give the money to the children? So a lot of times what people will do is, well, let me say, most parents say that when my child turns 18, it is highly unlikely that child is going to be ready to receive a big lump sum of cash. And so I really don't see parents often doing that. You can do that if you want, but usually it's an older age. They want the money to be held in a trust until the child gets older. Some of the ways to do that are listed in the third column here where it says children as adults. You can have the money held in trust until, after the age of 18 to be paid out at a later time. And then you can instruct that in that time period, the money can go towards post-secondary education. It can go towards health expenses. You can clarify, in this young adult's life, what sort of assets can be used or expenses can be used. And then you can have some sort of a payout structure. Some people will say, you know, let's give a third of the money at the age of 25, let's give another third at the age of 35, and the final payment at the age of 45. You can also do some sort of, you know, let's just have the trust pay out every single month until the money runs out. You can also provide discretion to the trustee and say, really, the trustee needs to decide when the money is paid, because I don't yet know what scenario my child is going to have, and I want somebody that I trust, someone else, to make that choice. You can also have the funds placed into a special needs trust. Okay, so if it looks like that your child is going to need government assistance that they're going to need to qualify for, it can be detrimental to give money directly to them, because they will sometimes that'll make them not qualify for those benefits. So a special needs trust is a type of trust where the money is used for their behalf, on their behalf, but it's not given directly to them. Or I have at the bottom of that column bolded, you can do a combination of the above. So what that means is you can say it is your desire that your child gets the money at the age of 25, 35, and 45 with certain expenses paid before then, but I'm going to leave it to my trustee to decide if a different arrangement is needed. You're going to leave some flexibility. Maybe instead of that, it needs to go into a special needs trust. Maybe it's not a special needs trust, but you know, you're concerned that your child is involved in some things, maybe as a teenager or something, and you just can see that it might be years before they sort of get their act together. And so you want that trustee to not give money to your child directly until the trustee thinks that it's time. So you can leave that sort of instruction in your trust. And then I mentioned all the way to the right there that, you know, I have talked to parents who say, well, I want to give money to my child, but I'm concerned that they're not going to save money for the grandchildren. So how do I protect money for that? Great. You can have a trust created for the grandchildren, and you can have it held onto, and you can have a trustee manage it sort of in a similar manner to the trust that you leave for your children. So these are some of the options that are available. I know that's a lot, but I hope that makes sense, that a revocable living trust has a lot of flexibility and can really manage things at different times of your children's lives. All right, I have here some scenarios, and it's a lot. I'm not going to go into all of this, but now that we sort of have a foundation for how assets pass to the next generation and the concept of different types of trusts, then we can think, okay, we have all these tools. Now, what do we do for different family situations, right? One scenario that comes up is second marriages. You might have a second marriage where both of the parents have significant assets of their own when they get married, right? So they may sort of want to, they're both working maybe, they both want to just kind of keep their assets separate. They're really not interested in combining those assets. And maybe one or both of them has children from a prior marriage. Okay, so there are different things that can be done about that. One is you could have each parent create a separate revocable living trust. It doesn't have to be joint, it could be separate trust where each parent can manage their money separately, and then they can set the distributions however they want. And then, you can just kind of keep everything separate. That's fine. You can also create a trust that puts language in there that says, and I have seen this, where you limit what the surviving spouse can do. And so what that means is, while you create one trust, a joint revocable living trust, while both parents are alive, one of the parents dies, okay, then the surviving parent, the concern I think that the deceased parent might have had is, well, I want to make sure that some of my money ends up going to my kids, right? Not just to my spouse's kids who survives me. I need money to go to my kids. And so how do I protect that? How do I know that after I die that my spouse isn't going to just, get remarried and then give all the money to their spouse or whatever? So there are ways to deal with that. You can, when the first parent dies, you can split it off, right? You can have money go directly to that first parent's children and then have other money go to the surviving spouse. You can also put language in the document that says that the surviving spouse is not allowed to change the beneficiaries on the trust after the first person dies. And so then that sort of creates some protection that they're not allowed to amend certain parts of the trust. So there's pros and cons to that, but there are different ways to sort of deal with that situation because it's a very common one. We're going to talk about single parents in just a second who perhaps are thinking about, they may have an ex who is the other parent of the child, but you've got custody, and after you die, you're thinking that the custody will go to the other parent, and we'll talk about that in just a minute because you're probably right, but you don't want the other parent to have access to the money. So if they're going to manage, if they're going to have custody, physical custody of the child, you don't want them to actually have the money that you're leaving for your child. Great, create a trust, name another trustee. It's really simple. That trustee that you trust is responsible to give money to for the benefit of the child based on your trust instructions. You don't have to name the physical guardian to be the trustee at all. We sort of already talked about disability, but sometimes one or both of the original grantors, or grantor is the term of the person that set up the trust, but one or both of the original parties that set up the trust has a disability, and so you can, of course, have the trust funds used for that. Another scenario that comes up is maybe you've got children that are sort of far apart, right? So one is already an adult and the other one is a minor. That's also something that these kinds of trusts can deal with. So you create the trust, you could have some assets split off for the adult child, and it can go to a trust or go directly to that adult child. And then you can have the minor child have separate trust created for him or her. And you can name, if you want, the adult child, if you trust your adult child, as the trustee for the minor child. So that's an option for you. Another thing that people are concerned about is, I'm leaving money to my kids. If they grow up and get married and then get divorced, I do not want my money to go to their ex. That is not happening. And so I've heard that more than once. You can deal with that as well. The rule around that, so I have practiced quite a lot of family law, and the rule around that in the state of Virginia, it is different in other states, but in Virginia, inheritance money is not subject to division at divorce unless it gets combined with marital assets. And then it can be subject, because that looks like the person who received the inheritance meant to gift it to their spouse. So they get married late, they get divorced later. That appears to be a joint asset that needs to be divided. And sometimes that happens even by mistake because they don't realize that rule. So if your child gets an inheritance and they keep the money in a completely separate account and never combine it with any marital money, then they're probably okay. But if you're not sure if they're going to do that, then what you can do is just have a payout structure for the trust that keeps the money in the trust and then just gives them money over time, little by little, instead of throwing all the money at them at once. So that's one way to deal with that. And then again, I've already mentioned the last one, but if you've got young children and you don't yet know if they're going to be responsible when they're older at certain ages, and it's hard to decide what age you should put in your trust, that's something that you can give that discretion to the trustee. So I know this is a lot, but I hope that this is helpful to see some of the flexibility of a revocable living trust. Really quickly on the trustee is you can name the same person as the guardian. You don't have to. You can have more than one trustee. So I have seen people say, I have 2 children, I want them both to be the trustee, 2 adult children. Great, you can do that. You've got to consider the relationship. Are they going to work together or not? You can name a corporate trust administrator or trustee. There are attorneys' offices that do that, trust companies that do that. It's always good to have a backup just in case something happens to your trust. And then keep in mind that a trustee can be compensated for the work that they do, and Virginia law has some guidelines in place for that. There's also a relatively new concept that is becoming more popular called naming a trust protector. And so what that is you name someone who is going to be responsible for dealing with any disputes that may come up during the life of the trust. So for instance, an attorney, you can say, instead of going to court and fighting about this is the person who can make choices if, say, the beneficiaries and the trustees are sort of squabbling about something in the trust. So that's sort of a cool thing that is more recent in the law that is becoming more popular. All right, so this slide goes back to everything that we've talked about. And remember this, I said at the very beginning that we're looking at various solutions, and you're the one who knows your family, you're the one that knows your children. You're the one that knows what is the best solution for you. So, you know, is a more what I call minimal solution a better one? It might be for your situation. Maybe it's just, you know, you've got adult kids, you just want to put them as the beneficiary of the will and your 401k account, and you're done. You're fine with, you know, them getting everything right away. That is going to cost you less money now for sure. And it's going to work if that's your situation. But as you sort of get a little bit more robust as we go to the right, things tend to cost a little bit more. So if you want to create a revocable living trust, which, as I say, and I've been pretty open about, for especially if you have minor children, it's really, really, really a good idea for a lot of parents with minor children. That does cost a little bit more to create, and it takes a little bit more effort now to administer because you have to retitle assets. But it has, I hope I've explained well enough that it has so many benefits. So I'm not going to go through every single thing here because I've actually already talked about all of these things, but just a reminder that what appears to be an expense now may end up saving quite a lot in the future. Okay, that's awesome. We got through the money stuff. Now we're going to talk about naming guardians for minor children. So we're going to start with while you're alive. Virginia has two different ways to name guardians for minor children. One is, and they have different purposes. One is you can execute a minor power of attorney. And this is a document that says, hey, someone else has authority to do certain things and take care of my child for a certain amount of time for limited reasons. And this might be you and your spouse are going on a foreign trip for a few weeks and you're leaving your child with the neighbor and you want the neighbor to have authority to take your child to the hospital, something like that. It can also be used for active duty military. It's really beneficial for that. The maximum that is allowed in the code for this is 180 days. Although if you want it to be longer than that, you just have to execute another one after 180 days. It does not give any more authority than is stated on the actual document. Parents' rights are not abandoned at all. It can be revoked at any time, and it does not involve the court. It's really a document that this person, this other temporary guardian, can walk around with when they have your kids, just to make sure that nobody questions their authority to do things for the children. The other one is called a standby guardian, and this is really when there is an anticipation of, okay, there might be a point where I cannot take care of my children. Typically, you see the reasons listed here. It could be incapacity, it could be deportation, your death. You know, after you die, eventually there's going to be a permanent guardian named for your child. But what about that in between time after you die and before that happens, right? If you think, you know, if you're facing incarceration or debilitation, those are the reasons that are named in the code as to why a standby guardian could become active. What it does is it provides both kinds of guardianship. And I mentioned briefly earlier, you've got that physical guardianship, which is called guardian of the person. And then you've got that financial guardianship, which is guardian of the estate. And so unless it's otherwise clarified in the document that you create, it's going to be both types. Again, parents' rights are not abandoned. The standby guardian can be relieved of their duties if it's, you know, there are steps that have to happen, but it's not a permanent abandonment. The standby guardian, in order to make this active, has to take the document that you created and petition it to the court, because the court has to actually provide this authority. And generally speaking, the person that you put as the standby guardian will become the guardian unless the court sees a red flag. So these are the two things that you can do while you're alive to prepare for someone taking care of your children if you cannot. All right. After you die, I've already talked about the different kinds of guardians, guardian of the person and guardian of the estate. The other thing is, if you do choose to put money into a UTMA account, you want to make sure that your will specifically says who the custodian of that account will be. Those are guardians. These are roles that you clarify in your will. They can't all be the same person. Absolutely, they can. There's no reason for them not to be the same person, but you might have different people in mind for them. I'll mention, I have this off on the red to the right, but a guardian of the estate. If you have a trust, you probably don't need a guardian of the estate because you've already named a trustee to manage the trust assets. So why would you name a guardian of the estate in your will? Well, we're talking about your death. If you die in a car accident, there may be insurance money that gets paid to your child. And because that money comes outside of the trust, then there would still need to be a need to have a guardian of the estate. So it probably wouldn't have to be used, but it's a good idea to have it named anyway, have someone named there. All right, in terms of guardians, Virginia is what is known as a parent-appointed state. There are states that are court-appointed and there are states that are parent-appointed. Parent-appointed states means that the court will appoint the guardians that you've named in a valid will. That's the default, right? Unless there are some exceptions, but generally speaking, if you name someone as a guardian in your will, that person is going to be the guardian. They don't need to have a whole contentious, court case about it. The exceptions to that, if the guardians that you name renounce their appointment, obviously they will not be appointed. Second, if they fail to claim the role within 6 months, so they can't come back in 2 years and say, oh, I'm the guardian. At that point, the court has moved on and had to name someone else. Or if you are a single parent, and I talked about this briefly a minute ago, and the other parent is alive and is a fit parent. Okay, so by operation of law, as a default, child's going to go to the other parent unless that person is found to be an unfit parent. Okay. If no guardian is named, then I think it's obvious the court has to choose the guardians. If the child is over 14 and no guardian is named, then the child can nominate a guardian who would be appointed as long as the court finds them to be suitable and competent. And then, the sad part is if no one steps forward to be the guardian, then that's why we have the foster system. So that's why we want to have these documents outlined so we know who should take responsibility. So my note to single parents for a second, if you're in that situation where you're thinking, okay, I don't want the other parent to have the child. We had a big custody battle. It took me thousands of dollars and lots of months, and I won custody from this other spouse. My ex, it's not spouse now, but from my ex, from the other parent. And at this point, I'm concerned that the other parent is not fit. Maybe the other parent is abusive. There's lots of reasons why this person might not be fit. If that's your concern, I put here, don't despair. There are things that you can do to set up success for another guardian. So like I said, generally, the default rule with very few exceptions is the way it's defined in the code is the natural parent. So one natural parent dies, child goes to the other natural parent. If somebody is going to someone has to come forward. If that parent is unfit, someone has to come forward and say, hey, court, this person is not fit, and has to create a custody case. If that happens, your guardians that you wish to have named, they're the ones that likely would do this, and you want to set them up for success. Okay, so what you should do, still name your choice of guardian in your will. Still name your choice of guardian in your will. Leave an affidavit with the will, not inside of the will, but sort of in a separate document next to the will, where you explain why you do not think that the other natural parent should have custody, that you're really concerned about the fitness of that parent. And if you've got evidence, leave evidence. And make sure that your would-be guardians know where that is, because you've got to set them up for success for demonstrating that that parent is unfit. And as I said before, place your financial assets into a trust and name someone else's trustee so you can just not worry about that. You're really focusing on providing evidence and giving the court some things to think about if there is going to be a custody case around the fitness of the other parent. So, all right, we're almost done, folks. Choosing guardians, I think parents know best how to choose guardians, but these are just some things to think about. You want to really think about everything, right? So what are the needs that your child would have? And again, I've said this a few times, but think about the course of your child's life, the way things would go if you were lost, and who in your life would be best to help with that person. Try to name a backup guardian, really important. You never know what the situation is going to be. Be very careful about couples. It's very common to say, I want, Joe and Betty to be the co-guardians of my child. And that's just fine. But what if Joe and Betty get divorced? Then who gets the child? So spell that out and make it clear, have a backup. If Joe and Betty are divorced, is it Betty or Joe that you want to have as the guardian of the child? As the child gets older, you know, if you've got a 16-year-old kid, ask him or her, you know, let them be part of the process. They may have some insights that you haven't thought about. Obviously, talk to your would-be guardians and make sure that they're willing to serve. I've already said it. Remember, you can have your would-be guardians be the trustee of whatever money you leave. You can also have someone else, so you have some flexibility there. Think about, you know, sometimes people will kind of nix would-be guardians based on finances, and that's fair, but I would say consider the fact that you're probably leaving life insurance. And if this person is emotionally the right person and has the capacity, I wouldn't let money be the only reason to not name that person. Remember, you can set that person up to have enough resources to take care of your child. And go ahead and do it. I've seen parents go, you know, some of my sweet clients, they just go around and around and around, and you know, it can take months and months, and they just can't decide who the perfect guardian would be. I completely understand how hard this choice is, but really just make any choice and get it written down. You can change it later. It's better to have an imperfect choice written down than no choice written down. So those are my tips on choosing guardians that I hope are helpful.